Welcome to FCLE Seminar, the Florida Civic Literacy Exam podcast, a podcast where we break down Supreme Court cases that shape our nation so you can pass the FCLE. I'm your host, Mercedes Musto, and today we're diving into a fascinating case from 1993. This one's called Shaw versus Reno. It's all about voting districts, race, and the 14th Amendment. It's a story about some really bizarre shapes and a big constitutional question. So grab your coffee or a map of North Carolina and let's get started. Landmark Supreme Court case number 21, Shaw versus Reno, 1993. Case background. Picture this. It's the early 1990s, and North Carolina is redrawing its congressional districts. I mean, this happens every so many years after the census to make sure representation keeps up with population changes. But you remember reapportionment from Baker versus Carr in Tennessee? What? You don't remember that case? Well, check out episode 10 then. Okay. But this time, there's a twist on North Carolinian reapportionment. See, the U.S. Attorney General stepped in and rejected North Carolina's reapportionment plan, kind of like this. Hold up, North Carolina. Your first plan only has one district where black minority voters are the majority. One minority majority? Well, that's not enough. Well, why? This might have something to do with the Voting Rights Act of 1965, but more on that later. Okay, back to Shaw versus Reno. So North Carolina goes back to the drawing board and submits a new plan. This time they create two minority-majority districts. Problem solved, right? Well, not quite. One of these districts, District 12, looked really bizarre on the map, like a choppy line that stretches 160 miles, mostly following the Interstate 85, through the north-central part of North Carolina. Can you picture that? Yeah. Well, see, 5 North Carolinians look at this choppy, stretched-out line, and they're like, wait a minute. This district's so weirdly shaped. Hey, wait, what is that about? Is this about race? See, the residents challenged that the reapportionment of this district, and then they were claiming that it violates the Constitution. So this case makes it all the way to the Supreme Court. Now, think about this. Keeping the 14th Amendment's Equal Protection Clause in mind, is North Carolina's oddly shaped district, allegedly possibly gerrymandered for voters by race, is this constitutional? And that's the question that the court has to answer. How do you weigh in? The court's decision. So what did the Supreme Court actually decide? In a 5-4 decision, the court decided that this does raise a constitutional question, and it is worth a closer look. Writing for the majority, Justice Sandra Day O'Connor pointed to the district's bizarre shape. She was like, and I'm paraphrasing here, look, this plan might seem neutral on paper, and it doesn't explicitly say race anywhere, but when you draw a district that looks this strange, it's hard to argue that it's not about separating voters by race. Wow. Now, the court didn't say racial considerations were off limits. After all, the Voting Rights Act of 1965, Section 4, talks about, well, quote, to assure that the right of the citizens of the United States to vote is not denied or abridged on account of race or color. And then it has to be, a bunch more stuff. And, well, hey, just look that one up. But there's a line. And North Carolina crossed it with this District 12 thing unless they could provide additional evidence. Meaning this, could North Carolina provide that this is indeed for fairness and not racial gerrymandering? This debate from 1993 remains unsettled. And quite frankly, we're still wrestling with this stuff today. The constitutional principle. So why does Shaw versus Reno matter to us in 2025? Well, redistricting battles are still a hot topic. States redraw their maps, and every time questions of race, fairness, and politics come up. This case gave yet another way to look at the 14th Amendment. That 14th Amendment Equal Protection Clause, for those who need a quick refresher, says no state can, quote, deny to any person within its jurisdiction the equal protection of the laws, end quote. And well, there's a lot more to it. It's a cornerstone of fairness in our legal system. Let's review. The key takeaways from Shaw versus Reno are, number one, the court established that bizarrely shaped electoral districts, even if created with the intent to increase minority representation, could be challenged under the Equal Protection Clause of the 14th Amendment. Number two, the court highlighted that unusually shaped districts, those that cannot be explained on the grounds other than race, raise concerns about racial gerrymandering, meaning that the shape of the district itself can be evidence of intent to segregate voters based on race. And number three, the court emphasized the need for legitimate, non-racial justifications for the shape and configuration of voting districts based on traditional districting principles. So before we wrap it up, let's think about this. North Carolina's heart might have been in the right place, trying to boost minority representation. But the Supreme Court reminded us that how you get there matters just as much as why. A district shaped like a highway might get the job done, but it also raises eyebrows, as we discovered, with some constitutional issues. That's all for today's episode of FCLE Seminar. What did you think? Did North Carolina go too far, or were they just doing the next right thing? Drop us a comment with your thoughts. We'd love to hear from you. Next time, we'll tackle another landmark Supreme Court case that shaped our nation. Until then, keep questioning, keep learning, and I'll see you back here soon. This is Mercedes Musto signing off. Join me again on FCLE Seminar, a Florida Civic Literacy Exam podcast, so you can pass the FCLE.